The ruling just dropped, and Washington is not okay right now. A federal trade court, a three-judge panel, just ruled that the 10% global tariffs Donald Trump imposed are unlawful, not procedurally flawed, not overreaching, unlawful. The exact word the court used: unauthorized by law, invalid. And here's why today is bigger than a trade dispute. This isn't the first time courts have done this to Trump on tariffs. It's the second time in under 3 months. The first time was the Supreme Court itself. I've been going through the filings and the reaction coming out of Washington for the last several hours. Let me show you exactly what happened, why it matters more than the headlines are saying, and what comes next. Because there are 3 things buried in this ruling that almost nobody is talking about yet. Let's start with where we are right now. February 20th, 2026. The Supreme Court issued a 6-3 decision in Learning Resources versus Trump. Chief Justice Roberts wrote the majority opinion personally, and the court said one thing clearly: the president does not have the authority to impose sweeping tariffs under the International Emergency Economic Powers Act. IEEPA is a law meant for genuine national emergencies, sanctions, asset freezes, not trade policy, not a mechanism for a president to unilaterally tax every import entering the country. 6 justices, including justices Trump himself nominated, agreed on that. Trump called it deeply disappointing. He said he was ashamed of the justices who ruled against him. And within hours of that ruling coming down, his administration did something that should have been the first signal of how this would end. They pivoted immediately. They reached for a different law. Section 122 of the Trade Act of 1974. An obscure, rarely used provision that allows a president to impose tariffs up to 15% for 150 days if there is a large and serious balance of payments deficit. The White House signed the executive order, and the 10% global tariff went back into effect under the new legal authority by February 24th. Keep that date in your head. February 24th, new tariff, new legal argument, new clock. Fast forward to Thursday, May 7th, 2026, the U.S. Court of International Trade, a 3-judge panel in New York, ruled 2-1. The replacement tariffs are unlawful, invalid, unauthorized by law. The majority wrote something precise and deliberate. The president's proclamation fails to identify a large and serious balance of payments deficit, as Congress understood that phrase when it wrote the law in 1974. Translation: Congress meant something specific when it wrote that provision: a genuine balance of payments crisis, a situation where the country's ability to finance imports collapses. Not a trade deficit, not a negotiating position, not a policy preference, a specific, measurable financial condition. And that condition does not currently exist. So the tariffs have no legal foundation. That's the ruling. Now here's what nobody's focusing on. The White House filed an appeal the same day. Within minutes of the ruling coming down, the Department of Justice filed a notice of appeal to the U.S. Court of Appeals for the Federal Circuit. And by Thursday afternoon, the appeals court granted an emergency stay. The tariffs remain in place while the appeal is processed. So the practical immediate impact is limited. Importers keep paying, businesses keep absorbing the cost, consumers keep feeling it at checkout. The ruling hasn't changed that yet. But here's what changed: the argument. 2 separate courts have now, in 2 separate rulings, told this administration the same thing. Presidents don't have unlimited power to impose tariffs by claiming emergency authority. The first time was the Supreme Court. The second time was a specialized federal trade court. The argument that the executive branch can simply declare a situation an emergency and use that declaration as a blank check for trade policy has now been rejected twice by 2 different courts operating under 2 different laws using 2 different legal standards. That matters beyond tariffs. That matters for how any future administration uses emergency power for anything. Here's the second thing getting missed. Trump's reaction Thursday night: he told reporters his administration would, quote, do it a different way. He went to Truth Social and called the ruling so wrong and so political. He blamed the Federalist Society for bad advice on judicial nominations. And then he added something significant. He said he hoped the Supreme Court would reverse the decision, quote, quickly and decisively. Think about what that sentence means. He's already planning the next appeal. He's already anticipating this. Goes back to the Supreme Court, the same Supreme Court that already ruled against him on tariffs 3 months ago, the same Chief Justice Roberts who wrote that opinion personally. The administration knows the Federal Circuit appeal is a bridge. The real target is the Supreme Court again. And that tells you exactly how confident they are in the Federal Circuit ruling going their way. They're not betting on winning there. They're betting on another Supreme Court review, hoping for a different outcome on a different legal question. That's a long shot, and the timelines make it even harder. Here's why. Section 122 tariffs expire automatically in 150 days. The clock started February 24th. That puts the expiration around July 24th. The appeals court told the plaintiffs to respond by June 5th. The government responds by June 9th. The Federal Circuit may not even rule before the tariffs expire naturally. And if the tariffs expire before the appeal is resolved, the whole legal question may become moot, which means the lower court ruling stands as precedent, unchanged. The administration would need a very fast Supreme Court intervention to change that outcome. And based on what Roberts already wrote in February, there is no indication that's coming. Now let's talk about Washington's reaction, because the split inside Washington on this is revealing. Democrats celebrated. Senate Minority Leader Chuck Schumer called it another rebuke of what he described as tariff chaos. Washington State Attorney General Nick Brown said, and this is direct, "It's American consumers and businesses that have ultimately paid for the president's illegal tariff campaign." That word illegal, from a sitting attorney general used without hesitation, is a signal about how far the legal community has moved on this question. Republican reaction was quieter. Some congressional Republicans had been privately uncomfortable with the tariff strategy from the start. A GOP congressman appeared on television saying, "Congress needs to be involved in trade policy," careful phrasing that doesn't attack Trump directly but signals acknowledgement that something has gone wrong with the legal architecture here. Markets registered the ruling with brief volatility before settling once it became clear the tariffs were staying in place during the appeal. Investors understand what courts say. They also understand what appeals courts do. But the deeper reaction in Washington isn't the public statements. It's the shift in the underlying question being asked in both parties right now. The question stopped being whether Trump's tariff strategy was good policy. The question is now whether any president has the authority to do what Trump tried to do, and courts are answering that question in a very specific direction. Here's where this stands right now. Supreme Court ruled in February that IEPA cannot be used for tariffs. That ruling stands. Court of International Trade ruled in May that Section 122 cannot be used for the current 10% global tariff. That ruling is on appeal but currently paused by an emergency stay. The 10% global tariff remains in effect through the stay. Section 122 authority expires around July 24th, regardless of what courts do. Industry-specific tariffs under Sections 232 and 301, steel, aluminum, autos, semiconductors, those remain intact and were not challenged by these rulings. 3 things to track going forward. First, the Federal Circuit's pace. If the appeals court rules before July 24th and upholds the lower court, the administration has no replacement legal authority on the table. If they don't rule in time, the tariffs expire and the legal question may dissolve. Watch the briefing schedule. June 5th and June 9th are the key dates. Second, Section 301 and 232 investigations. The administration announced plans to accelerate these country-specific, sector-specific investigations after the Supreme Court ruling in February. These are slower processes, but they create longer-term tariff authority that's far harder for courts to challenge. The administration is quietly building the next framework while the current one is being litigated out of existence. Third, Congress. The Supreme Court's February decision created a specific pressure point. Section 122 tariffs require congressional extension after 150 days. That vote would fall in late July, just before the 2026 midterm campaign season heats up. Republican members of Congress would have to vote publicly to extend tariffs that courts have already called unlawful. That's an uncomfortable position. Watch whether congressional Republicans push for that vote or quietly let the clock run out. What this ruling actually established, separate from the tactical fight, is something more durable. Two courts now hold that presidential emergency powers have defined limits. Those limits apply to tariff policy specifically and to executive overreach generally. Every ruling in this direction adds weight to the legal framework that constrains future presidents too. That's a precedent that outlasts any individual tariff or any single administration. Friday morning, Washington woke up with the tariffs still in place, but the legal foundation under them shaking again. The administration is appealing, the courts are moving, Congress is watching and calculating, and the timeline is compressing fast. That's where we are. I'll track the Federal Circuit briefing schedule and any movement on Section 232 and 301 investigations as this develops. Subscribe so you don't miss the next development when it lands, because based on the pace of this story, that won't be long.